Hi, this is Tom King, and we're here on our next topic called International Arbitration Preparation. We're here with both Lindsey Mitchell and Richard Deutsch of PillsburyLaw.com. Let's go ahead and jump straight to the topics. Richard and Lindsey, thanks for joining us. Let's go ahead and share the screen. Who has the column on the left when it comes to this topic? At exhibits and evidence.
That's me. This is Richard Deutsch.
Go
So
ahead, Richard.
let's jump right in. So we're talking about exhibits and evidence in international arbitration. And as you'll see, as Lindsey and I go through these, there is a big difference in a lot of this process, the big difference between international arbitration and the things you generally see in domestic U.S. litigation as well as in domestic arbitration. So it's international, it's very different. Um, so let's start talking about exhibits and evidence, which everyone is used to seeing in their different jurisdictions and in their different forms of litigation. But here's how it usually works in international arbitration. Um, so first of all, um, you have to be very evidence is the foundation of any arbitration case. It establishes facts, um, supports legal arguments, determines the outcome sometimes. In international arbitration, though, you've got parties coming from different legal traditions and procedural backgrounds, and the handling of evidence can be particularly crucial because it's got to make sense to people from different legal backgrounds. The rules governing evidence are going to be more flexible than what you usually see in U.S. litigation, and this flexibility can actually place a greater burden on the parties to present their case in a clear, well-organized, persuasive manner. And so you have to really understand how to properly collect, present, and challenge the evidence to make sure the tribunal has a full and accurate picture of the dispute, because they're going to have their certain expectations. By the tribunal, we mean the arbitrators. They're going to have specific expectations of how they expect to see things. So that's why you have to pay really close attention to it. So that's why we jump straight into sort of know the rules. And here's what I mean by knowing the rules in international arbitration. Um, we're not talking about applying, some jurisdictions' local rules of evidence or procedure, or in the US, the federal or state rules of procedure. This is different. In international arbitration, each arbitral institution, the key ones being the ICC, the LCIA, Singapore International Arbitration Center, the International Center for Dispute Resolution, among others, they have general guidelines for evidence in their rules, but they don't really have anything specific, right? The breakdown of timing and the format are not in the rules. So
Okay.
the schedule and methodology are usually determined by the arbitrators and the parties, or the arbitrators made us adopt what the parties want. Oftentimes, they'll look to outside sort of soft sources to help guide um, evidence and exhibits. And one common source is called the IBA Rules on the Taking of Evidence in International Arbitration. And these provide guidelines on document production, witness testimony, expert reports. And you should follow whatever the procedures that the arbitrators decide, follow those orders closely, follow that procedure closely, because if you have two parties or more turning in different forms of things to the tribunal, not only is it going to cause confusion and maybe some extra expense, but it can really damage your credibility that you're not following the procedure that was set forth by the arbitrators. Um,
When I think of an international arbitration, one of the first things I think about is my predicates for getting in evidence based off of the rules that apply to that arbitration.
exactly, and that's the point. And another thing we'll get to in a minute, but getting the evidence in an international arbitration, getting it authorized or authenticized is not an issue in international arbitration. It's deemed to be authenticated if it's included with your exhibits, with your pleadings or in any other format. So the use of affidavits and swearing these things up and getting them in, that's not an issue in international arbitration. It's a general presumption that they're legitimate and authenticated. Um, so pay close attention again. The scope of document production is often more limited than in litigation. So think about this when you're going into an international arbitration. If you're going in and you're just kind of hoping that there's going to be this broad discovery and it's going to help you build your case, That's not often a sound strategy in international arbitration. The expectation is that you're going into this and you've got most of your evidence, you have your case in order. You're not going to get broad fishing expeditions in document discovery or anything like that. It's going to be very, very narrow. Um, so that's a big strategic point to think of in advance. But it's also important to the early phases of knowing how the evidence is going to be collected and presented, following the procedures, because that can also help your strategies to how you're going to form your case and try and sell it and persuade everyone.
We've got about 3 more minutes for this column. What box do you want us to look at next?
So let's take a look at um let's go to just the next one, the exhibit list, because this really ties into what I'd said before. Unlike what you're used to seeing, in a US courtroom where everybody kind of follows the same format. Again, this is not in any of the rules that are applied for the internet for the institute, whatever administrator is doing it. So again, you want to go to the procedural order that's been put together and follow the specifics in there. And those specifics are going to have things like how they're going to want to see exhibits numbered. Is it going to be numerical, alphanumerical? Are you going to put a C for the claimant's exhibits? You're going to stamp the respondent's ones with an R. How are you going to do that? And maintaining that throughout the arbitration, because once you get to the hearings, everyone is going to have a joint bundle. And that's got to be assembled in the way that the arbitrators anticipated in advance. Again, you don't want to be the party showing up at the hearings without the exhibits in the format that the arbitrators wanted. It can affect efficiency, and it can also adversely impact your evidence.
What do we want to know about audio evidence, video evidence, and photo evidence?
Yeah, I would like to skip down to video and photo evidence. Really, when you put the expectation that arbitrators are going to have, because oftentimes you're not in a courtroom. You can sometimes be in a little conference room. You can also be in a big hotel conference room, depending on where you are as well. I mean, ballroom. So you've got to make sure that the quality, the visibility and the audio are clear, that it's going to work in that room, because the expectations are going to be, you're the arbitrators in that room. You're looking up at that big screen, and you want it to be clear and you want it to be right to the point. So you don't want to have long videos where the arbitrators can't tell exactly what it is they should be focusing on.
Okay.
And again, follow the format set forth, and follow finally with the final point. I'd like to look at something that people may not be that familiar with, which is the sworn affidavits and statements. And Lindsey will get into this more in her section, but the affidavits are not unusual. In fact, they're very common in international arbitration. You have witness statements, which is basically a long witness affidavit, which is their direct testimony. It's extremely important because that may be their only direct testimony, the only time the arbitrator is hearing anything from them at all until you actually get to the hearings. So that witness statement has to be done in a certain things to think in a certain way that the arbitrators again are expecting it, and the details for how that's done will also be in the procedural order. There's a few cultural things to think about. When you're drafting this and you've got people from different jurisdictions around the world, maybe some language issues, I would draft these witness statements. Don't be cute, don't be overly ambitious. Just keep it straightforward and stick to the facts. Not only does it make it easier on the arbitrators, but a practice tip: the more that the witness sort of goes off the reservation, then there's chances they could walk into a trap and end up testifying about something that they really aren't that comfortable doing.
Perfect. Lindsey, I think what you want to focus on next is the witness column. Where do you want to focus our attention?
Sure, we'll just start right at the beginning. Similarly to what Rich was saying, witnesses in international arbitration often are going to be treated with a bit more flexibility, because the way that you use witnesses aren't going to be dictated by any sort of, you think of like Texas court rules or our federal rules of how court proceedings are conducted. Instead, the way that witnesses are used, it's going to be heavily dictated by what the parties decide and what the tribunal decides, often in the procedural order. So one important thing to think about is that in international arbitration, because you're often crossing, jurisdictional boundaries, you may have a case that comes from the civil law tradition versus the common law tradition. And there are interesting differences in how witnesses are treated in those different jurisdictions. So for example, in jurisdictions with common law traditions like the United States or like Canada, like the United Kingdom, witness testimony often plays a very central role in dispute resolution, like you would see in a court proceeding. Witnesses typically can be subject to direct and cross-examination. Often it could be a bit more adversarial in terms of how they are questioned and crossed. And oral testimony of witnesses often carries very significant weight. So that can be true also in civil law traditions, but typically in civil law jurisdictions like France and Japan, for example, written submissions may be more weight may be placed on written submissions. It may be a little bit less adversarial in terms of how witnesses are crossed during the oral hearing. And witness testimony in general could be more limited in scope. So often in the common law tradition, we try to create a broad narrative of the case using witnesses. And in civil law jurisdictions, it may be a bit more focused, you could say. So in international arbitration, like I was saying, depending on what the parties decide, what the tribunal decides, so you can kind of draw from both of these traditions to determine how witnesses are going to be used throughout the international arbitration hearing and proceeding. We can move on to types of witnesses. So there's two critical types of witnesses. You have fact witnesses. These are going to be the individuals who provide firsthand knowledge of whatever event or underlying transaction took place. Maybe they are employees or people who worked in the government. That's especially the case if we're talking about an investor-state dispute. And often they will present their testimony in the form of a written witness statement, like Rich was saying. And then they may also testify at the hearing. Then you also have expert witnesses who are very critical. They usually don't have any firsthand knowledge of the dispute, but they're generally highly skilled in some particular profession. And they're often used in arbitration hearings when the tribunal requires specialized knowledge of a dispute. So think about a dispute that is going to center around engineering or a field like economics or international law that is going to require someone to come in and give their expert opinion on that to help the tribunal determine what happened and what the outcome of the case should be.
And Lindsey, do we find that expert reports are a critical component of international arbitration?
Yes, they are certainly a critical component, just like a fact witness statement. A factual witness would submit a witness statement, and then an expert would submit an expert report, typically in advance of the hearing, so that the tribunal can familiarize themselves with the report and then be prepared to ask the experts any questions that they may have on their report. So generally, characteristics of a witness statement or an expert report that are critical, you want the report to be clear and a structured presentation of facts. So very easy to read. Again, like Rich said, not trying to get too cute with it. And you generally have to include a declaration that the statements given are true. And then this is particularly relevant in the case of expert reports. You have to disclose any relationships that could potentially affect partiality, because these experts obviously are, they're often hired to produce these sorts of reports. So it would probably be relevant to one or the other party to know, okay, how many times has this particular expert worked with the opposing side, for example. And then moving on to cross-examination and witness examination procedures. So just like you would have in any typical US litigation, the hearing stage of an arbitration often will provide the opportunity for the opposing side, and often the tribunal itself, to cross and examine or to ask the witnesses any questions. So usually if your party is your party's witness, you will have the opportunity to ask them direct questions to clarify anything that potentially they said in their witness statement or in their expert report. And then the opposing side will have the opportunity to cross. And then the original party will have the opportunity to re-examine the witness again. And it depends, again, it's going to be up to the tribunal itself often to figure out the approach to how witnesses are treated during the hearing itself. So for instance, under the ICC and LCIA rules, those are two arbitration institutions, tribunals have broad discretion to manage witness examination. So that's going to play a critical role in how witnesses are treated during the hearing.
Got about 1 minute to finish this column. Go ahead.
Sure. So let's I'll just particularly focus on preparing the witness because again, similar to what we talked about earlier, there could be differences depending on what jurisdiction, what law is controlling in the case and what is allowed in terms of witness preparation. So in some jurisdictions like the US, generally we can extensively prepare a witness, whereas in other traditions, they really focus on more spontaneous testimony. They really want to get away from anything that could be considered coaching the witness, for example. And so they may encourage more unrehearsed testimony. And then, above all else, best practices, you want to try and select a witness to the best of your ability who is going to present truthful, reliable, and consistent testimony.
Super. So we're looking at the first half of the help sheet on international arbitration and preparation. On this side of the help sheet that everyone's following along with, we've looked at exhibits and evidence and then witnesses. Now let's go to the second half of the sheet. And I suspect that, Richard, that's probably back to you.
Yeah, actually, I think Lindsey is going to pick up the pleadings and memorials, and I'll finish.
Go ahead, Lindsey.
Right. So in international arbitration, written submissions really structure the entire arbitration process. And while the way in which the written submissions are structured is going to depend a lot, again, on what the parties decide and the procedural rules that are going to govern that arbitration. So the most typical way that the arbitration commences, it's with the notice of arbitration or the request for arbitration. And those are just different terms depending on whether you are in a commercial international arbitration or an investor state arbitration. So usually the process by which this notice is filed is going to be detailed in whatever the underlying contract is, or sometimes the underlying treaty in the case of an investor state case. Usually it will specifically say in the arbitration clause, it'll point to some arbitration rules, which will then have the procedure by which the parties will file the notice or request for arbitration. So this
and really quick, just to jump in, Lindsey, you've heard both of us constantly use the phrase the arbitration process, throughout the arbitration process, the arbitration proceedings. We're not just talking about the hearings. The hearings are at the very end. The international arbitration process we're referring to literally starts at the initiation of the arbitration through the filing of the request for arbitration or the notice that she was just explaining,
Right.
all the way through all the pleadings, all the way through till we get to the hearings, a year and a half, 2-3 years later, and then the award whenever that comes. So it's a whole multi-year process.
Mm-hmm. Yes. So the initial sort of pleading that sparks it all, the entire process, is this notice or request. And it's just going to have to, include like the key details of the dispute, the parties who are involved, and any factual basis for the claim. Also, this notice could include a party in the notice may nominate the arbitrator that they want to have as part of the tribunal. But again, all of this is going to be either detailed in the underlying arbitration clause or in whatever rules govern the arbitration as selected by the parties. After this initial filing, often what will happen is that the parties will meet with the selected arbitration tribunal, and they will have discussions to determine a lot of the procedural steps of the arbitration. So for example, this would be to determine the timeline of the arbitration, when the different types of written submissions, the deadlines by which they have to be filed, logistics for the hearing, other logistical sort of matters. So one important decision that may arise during this step is whether to bifurcate the proceedings. So that means basically to divide the arbitration into separate phases if there's different issues that must be addressed. So one common way of bifurcating a proceeding would be to split the jurisdictional issues of a case from the merits of a case. And this is important when it comes to the pleadings, because if you have a bifurcated arbitration, then that means the parties are going to submit one whole round of pleadings just on jurisdictional issues. And then if the case continues moving forward, they have to submit an entire other round of pleadings. So, yes. So once you get all of that out of the way, then the parties can move on to submitting their the initial statement of a claim in a commercial arbitration, or in an investor state case, it would be called the memorial on the merits. So this is going to serve as the major foundation of the claimant's case. So they're going to present all of their factual and legal arguments in much greater detail than they did in that initial notice that they filed. And this also will probably include witness statements, those expert reports we talked about, documentary evidence, and legal authorities.
You've got about 2 minutes left to finish the column. Go ahead.
Sure. So then in response to that, the respondent would submit their statement of defense in a commercial case or a counter memorial in an investor state case. So similarly, in this document, they're going to respond to all of the claimant's allegations and set forth their legal and factual arguments. And additionally, if they have any counterclaims to raise, they would do that in this statement of defense. So then Rich had sort of talked about earlier documents and evidence, so I can kind of skip over that part. But again, just remembering that document production and what parties request from one another, it's going to be heavily dependent on what the tribunal decides or what the parties had already decided upon during the procedural steps that took place early on in the arbitration. And then in response to the initial response, the claimant could then submit a statement of reply or a rejoinder in an investor state case. And then it kind of always follows that typical structure. The claimant submits, respondent submits, claimant again, respondent. And then depending on the case, the tribunal may request that you submit a pre-hearing brief, which is going to outline again the main issues of the case. And it's kind of your opportunity to submit the outline of your case as you're going to present it at the hearing. And then additionally, this isn't always the case, but a tribunal may ask for a post-hearing brief in which they may ask the parties to detail any more complex issues that were discussed at the hearing, or maybe something came up at the hearing that wasn't previously addressed, and you could do that in your post-hearing brief. And yeah, that's kind of an overview of all of the written submissions in an international arbitration.
Great. So Richard, now as we're coming home, I believe we're dealing with the last column here in your help sheet. What I see that being is arbitration award drafting, because if it doesn't make it into the award, what did you achieve, right?
Exactly. And that's exactly what I'm getting at in this whole section, is that, the goal of of going through the entire international arbitration process, the time, the expense, all the work, the goal is to get this business dispute resolved. And so one of the ways it's going to get resolved is to have a final award that can be enforced. You don't want to go through all this effort and have an award that a court is not going to enforce because you didn't follow a particular procedural requirement or among other things. And so throughout the arbitration process, the arbitrators have to keep in mind what their purpose is. And it's really complicated though, because international arbitration, you've got this interplay of laws and rules that can make even the simplest dispute very, very complicated. So when we jump into the next topic, to familiarize yourself with the international arbitration rules, this is really my point, is that so much of my work as an arbitrator is done at the very, very, very beginning. Once I'm appointed, I go straight to the arbitration clause, I go straight to the contract, I start going to the institutional rules. Because each set of arbitration rules contains provisions regarding the form of the award. And the arbitration clause of the contract will often contain information about the type of award to be rendered. By that, I mean, for instance, some arbitration rules require a reasoned award, as opposed to just 3 sentences of this party wins, here's how much money they get. They want a reasoned award. That means the decision is going to require a thorough recounting of the facts, parties' positions, claims and defenses, and finally a decision setting forth the reasons for it as well as the damages. The arbitration provision will also have requirements as to how the arbitrators are to decide the matter. Is it majority of arbitrators? Things like that you have to really pay attention to. Another thing that's really common these days is the rules will often contain, or the arbitration clause will have a deadline for the rendering of the award, because everybody's trying to cut back on costs and time, and they may say, for instance, the deadline is 30 days from the closing of the record, meaning the award must be drafted and rendered within 30 days of the time that the tribunal notifies the parties that there's no more information to be submitted. 30 days is very ambitious. It can be done, but the point of it is you have to be aware that that's going to be coming. You don't have a lot of time. Another important thing, if you go to the next box, checking the governing law, and this is what I mean by that. Because as I mentioned above, there's all this interplay of laws and rules going on. So it may seem obvious, but oftentimes arbitrators become so consumed with the facts and the interesting stuff in the case and the supporting evidence, they don't focus on the fact that the decision must be tied to the governing law. So in other words, like a regular court decision, you've got to be able to tie in the evidence with the law and see if somebody met their burden. The governing law is usually in the underlying contract. It'll say the contract will be determined by the laws of wherever, but sometimes it's determined after the arbitration is underway, because sometimes the contract won't have a governing law provision, believe it or not.
Right.
And so, or the parties can say, well, yeah, that's the governing law. However, because this is in this jurisdiction, but all the action occurred here, maybe these other laws have to be included. And then it's up to the arbitrators to decide which legal standard they're going to apply to their claims and defenses. And in international arbitration, I keep talking about all these different laws. You've got the governing law of the contract, the law of the seat where the arbitration is going to be held, whatever law may have to be used to interpret the arbitration clause, perhaps the laws of the courts in related jurisdictions, as well as maybe the laws of the jurisdiction or jurisdictions around the world where you may want to where this award could be enforced. So you've got all that going on. Oh, yeah. And by the way, we've got the actual rules you're following. Oh, yeah. And also we've got the procedural rules that the arbitrators set forth. So you can see where it's complicated.
Oh, and this arbitration will be in this language.
Right. Then there's a language issue as well. And you know what? Sometimes they don't have a language specified in there. And you've got parties from, you've got contracts in one language. Everything occurred in a country under another language. So these little things you really have to stay on top of. A few tips early on. So drafting the award should not wait until the very, very end after everything's concluded. You've had 2, 3, 4 years of a massive amount of information. It should be starting to get accumulated as it's going. Whether just drafting, oftentimes in these big awards, just getting through the procedural part can be 20 pages. And then you've got to lay out everyone's claims and defenses, and that can take a lot. So it's a good idea to keep this going. And for the arbitrators themselves, if there's three of you, start assigning things early on. Hey, you watch the procedure, you keep an eye on this, you keep an eye on that. So when it comes time to actually start drafting, it's not all over the place. You're not starting from nowhere. I think that a few other practical tips towards the end, the last three points I have. The first, draft honestly, and by that I mean the arbitrators, as the case is going, it's not uncommon for them to have various discussions amongst themselves. But as you're getting closer to the end, or maybe even after deliberations, you've got to be honest with the other arbitrators. You can't, I mean, you can just go along with everyone else if you want, but if there's going to be an issue early on, you can tell that the arbitrators are not agreeing on some key points. That's got to be brought out and dealt with early on. It can't just carry over until the very, very end. Nobody can make up their mind on one particular point, particularly because whichever way you rule can affect the decision tree and where the rest of the decision is going to go. So it's important to just say it outright and don't try it's not the point of being on a tribunal is not to be friends. The point is to get the business dispute decided and decided correctly and in a form of an award that can be enforced.
You've got about 1 minute left to finalize this column.
Right. So second to last seems like common sense. Carefully review everything before you finalize that award. Okay, because the parties are going to read that award over and over and over and over and over, and they're going to look to find something they think is inconsistent and make a decision on enforceability. So to the best you can, go back over and check everything. Put reminders in a footnote, do whatever you want, but whatever it takes to make sure you get it right. And finally, make sure you sign when the award is finalized and you're ready to go. Make sure it's signed and dated, and you expressly state at the signature that it was signed at the place of arbitration.
Have you ever had an arbitration award that they forgot to sign?
Not that they forgot. No, I have not. But I have seen awards where they sign them on different dates or different places, and it just causes a lot of confusion. I know this sounds really nitpicky, but everybody goes over every single word to find something to challenge on.
Richard, take about 30 seconds to tell us about Pillsbury Law.
So Pillsbury is an international law firm. It's been around for a really long time. It's always sort of prided itself on being sort of cutting edge, whether it's, technology wise or in new spaces. We have offices worldwide. There's almost 800 lawyers everywhere from Texas to New York to Washington to London to various parts of Asia. All practice areas, and you kind of see it all come to fruition in our international arbitration group because we often get called in by various practice groups that do things all over the world, including international contracts. And when those international contracts don't go the way a party wants, it can lead to a dispute. So people like Lindsey and myself are put in a pretty unique situation where we have to learn all these different practice areas all the time because we may get a call from our pharmaceutical group saying there's a pharmaceutical dispute in Switzerland, and we have to learn about that. Or you've got a power plant in Ecuador that's having issues with subsidies not being paid. So you have to become an expert on that. And so
I've got to think that in North America, you've got to be one of the largest international arbitration firms.
Our practice group is right up there because it's really and they're mostly in cities that make a lot of sense for this. In the US, it's Washington because of trade, New York because it's the commercial center, and Houston because every energy company in the world is here and they all do international business.
Perfect. Okay, well that finalizes our presentation on this topic. Thank you and goodbye.
Thank you.